that again. Say that again.
I said he should be on his way to the General Legal Counsel. Not because he's a minority leader, but because he's a lawyer. And he scandalized himself in his profession.
What if he has facts? What he has facts about the judge being paid?
So he goes there to show the facts. The facts will be his defense. He goes there to produce the facts as defense. But you can't scandalize the courts in the way he has done. As a lawyer, he can't do that. And he's a lawyer. So that's what you should understand. And secondly, I'm scandalized by the arguments of Ajapa Mensah. He's a lawyer. And that is the court of first instance, for God's sake. The decision is the court of first instance. And in the election petition, the decision ends at the Court of Appeal. And Martin Yindang has told everybody in Ghana that he's appealed against the decision. He's appealed the decision to the Court of Appeal. So why can't you wait and argue your case in the Court of Appeal? And he seems to have lost what happened in our recent history. How can you sit on TV and say that you can go to court and ask? And the court will give you what you have not asked for, and that will never happen. It happened. Afenyo Markin went to court for an interim injunction to restrain the speaker from declaring the seat vacant. He was given a perpetual injunction. How can you sit on TV and say that you can go to court and ask? And the court will give you what you have not asked for, and that will never happen. It happened. Afenyo Markin went to court for an interim injunction to restrain the speaker from declaring the seat vacant. He was given a perpetual injunction. He was given a perpetual injunction. What are you saying, Ajapa Mensah?
What did you say? Did you say that was allowed? That was okay?
Was it not?
What I'm saying that he didn't ask for it. Even Afenyo Markin did not ask for a perpetual injunction.
Exactly. So you faulted the court for that, did you not?
I'm saying that he went to court to ask for an interim injunction. That's the argument. And he was given what he did not ask for.
And my question is, what did the NDC say? That judgment was procured by... The proposition that you can go to court, and be given what you have not asked for, it cannot happen. But is it not curious? That you have a petitioner who goes to court?
But I wrote it down.
Over 41 polling stations. As I understand, the 41 polling stations will give you a total of about 500 votes or so. I don't know if I get my figures correct about that. You would know. And the difference in the win between him and Yindang will be about 1,600. So if you faulted the 500, votes, it doesn't do anything. How do you go to nullify the whole results? That's the question.
So again, Samson, we must await the decision of the court, the written judgment of the court. But I worked in Pandai. Before the elections and on the election day. And the collection center, which had been gazetted, was moved without notice to the petitioner, the party who petitioned in court. So you have to understand, you have to read the whole judgment to understand the thinking. But be it as it may, what I'm saying is that as lawyers, we know that the High Court's decision is a decision of a court of first instance. And an election petition doesn't end at the High Court. It ends at the Court of Appeal. And there are many cases, and in the Dr. Yakubu's case that they cited, I was involved in that case. The court used a mathematical formula to arrive at a decision that Dr. Yakubu was not validly elected as MP. The Court of Appeal reversed the decision and condemned the decision of the High Court. So you cannot run ahead of the total, determination of the matter. And that is why Speaker Bagman, keenly aware that the Court of Appeal, the High Court, is not the final court in an election petition, said Nyindam cannot lose his seat until the Court of Appeal listens.
No, that's not what Bagwin has said. Bagwin has said that the attempt to prevent Nyindam from being in the House without waiting for the statutory 7 days of stay after a judgment is wrong.
But to be fair,
that's what Bagwin said.
Speaker
that's
added
what Bagwin
that,
said.
Yes, he added, Inusah, if you may, he added that the filing of the motion for stay pursuant to the appeal could extend that 7-day statutory.
But he said
so. I was listening to him.
Samson,
no,
but Samson, you know that even if a decision of a court is given statutorily and by practice and convention of the judiciary and of lawyers, we do not execute the judgment until after the expiration of 7 days.
Yes.
We know that. And we do that for good reason. Secondly, he's filed a stay of execution. Yes, the Court of Appeal and the Supreme Court have said that a stay of execution does not operate as a stay of the execution of the judgment. So the High Court, or in fact, you have to file it in the High Court.
Okay.
The High Court will have to pronounce on it.
All right.
Then we know that the final court in an election petition is the Court of Appeal. So why will we run ahead of time?
Right.
So we can't criticize the decision of the High Court.
Thank you. But you will agree. You will agree that what the minority sought to do in Parliament was wrong. The very day the judgment is given, you are saying the man should not sit in the House, when by law there is automatic stay of the judgment for 7 days.
That's theatrics. That's Parliament. That's theatrics. But because the one who was saying so is also a lawyer, and he knows it. So that's theatrics.
But lawyers can get it wrong. Thank you very much. Yes, Susan.
But Samson, you should know that, if you are in Parliament and there is a decision annulling your elections, you will take steps to ensure that you vindicate your position and your election. And so Nyindam will try to take steps to vindicate the position that he was validly elected.
Okay.
And we
thank you. Let's give Susan the opportunity to also say something.